Good morning, everyone. I'd like to wish everyone a very happy new year, and I'll call our first meeting of 2026 to order at 9:16 a.m. I'd like to welcome council members on Zoom today and everyone who's joined us on the live stream via YouTube. We'll begin by acknowledging that the CDHO office and staff operate out of Toronto, Ontario, within the Dish with One Spoon territory. The name Toronto originates from Takaranto, a Mohawk word meaning the place in the water where the trees are standing. Toronto is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now the home of many diverse First Nations, Inuit, and Métis peoples. Toronto is also covered by Treaty 13, signed with the Mississaugas of the Credit, and the Williams Treaty, signed with multiple Mississaugas and Chippewa bands. We wish to acknowledge this land on which CDHO operates and are thankful to be able to work and live in these territories. Welcome to Glenn and the CDHO staff in attendance. It's always nice to see you at our council meetings. I'd like to recognize the great work that the CDHO staff does on the operational side of the college to meet our public interest mandate. I'd like to welcome Julie McCura, our legal counsel. And lastly, I'd like to welcome our newest council members who are joining for their very first official council meeting. Derek Gartshore, our newest public member, Crystal Afzelzada, and Kylie McElray, both elected professional members. So moving to our agenda, 1.2, our code of conduct. Council members shall conduct themselves in accordance with the bylaws. We have all read the bylaws, section 3.7. I will remind council members that we are to act in the best interest of the college and the public of Ontario, and as such, we should ensure that we keep this in the forefront of our minds in our discussions and while making our decisions. As housekeeping for our meeting, please ensure you speak loudly and clearly, and please ensure you mute yourself when you're not talking and come off of mute when you are. Moving to the agenda, item 2.1, the approval of the agenda. Does anyone have any items to change or add to our very short meeting today? I'm not seeing any. So our motion is that council moves to approve the January 9th, 2026 council meeting agenda as presented. Do I have a mover, Jen, a seconder, Lori, all in favor? Okay, carried. Conflicts of interest. Does anyone have any conflicts of interest to declare with any of our agenda items today? I'm not seeing any. So we're moving to agenda item 4.0. So I'm going to turn things over to you, Glenn, for the election of the executive committee.
Thank you, Michelle. And just before we get started, I just want to confirm that everybody can hear me. Well, thumbs up. Great. All right. So Happy New Year to everyone. And certain particular welcome to the new members of council, and best wishes to each of you individually for 2026 and as a group as well for as we move forward accomplishing all the great work that council and the college has been engaged in. So we would look forward to all of 26 and all of the promise that it carries with it. This morning, I'm going to conduct the election in accordance with Schedule 2 as part of the bylaw. Nominations to any position on the executive committee may be either by self or from any member of council. The executive committee itself consists of a maximum of 5 council members elected by council annually. All council members are eligible for election to the executive committee. 3 members of the executive committee must be registrants of the college, and 2 members must be publicly appointed members of council. There is no limitation on the number of years a council member may sit on the executive committee. However, each position has a maximum number of aggregate years that may be served as follows. The chair, 3 years. The vice chair, 3 years, and executive member at large, 3 years as well. The election process today will begin with a call for nominations for the position of chair, followed by that of vice chair, the call for nominations for, and then a call for nominations for the remaining 3 executive positions. I will call for nominations until there are no more nominations, and I will then make a second and third and final call. Receiving no additional nominations, I will close the nominations. Should only one council member be a candidate for the position, I will declare that candidate elected by acclamation. Should there be more than one candidate for a position, an electronic election using the Board Effect platform by secret ballot shall be conducted. And I believe those new members of council who may not be connected to Board Effect platform at this point have been given instructions by Veronica about submitting their ballots by email. I just wanted to confirm that with Veronica. Is that true, Veronica? Yes.
Yes, that's correct.
Thank you. Each nominated candidate who accepts a nomination will be given an opportunity to briefly address council. The election will be carried out on the Board Effect platform. Veronica will create the ballot by loading the names of the nominees into the ballot. Once the ballot is created, it will be made live on the Board Effect platform. Once you are informed that the ballot is live, you should refresh your Board Effect window. You will then see the ballot at the bottom of your homepage on Board Effect. If you're having difficulty with the process, please email Veronica directly. I'm appointing Eric Bruce and Suzanne Fox as scrutineers who will go into a breakout room and review the electronic ballot counts. Once all ballots have been registered, the scrutineers will return the results to me and I will notify council of the results of the ballot. If an election is necessary, the following processes will apply. When there are 2 candidates, the nominee who receives 51% of the votes cast is deemed elected. When more than 2 candidates are nominated, the nominee who received the lowest number of votes in each election shall be deleted from the next ensuing election unless one nominee receives a majority of 50% plus 1 of the votes cast on the ballot. This procedure shall be followed until one nominee receives a majority of the votes cast. In the event of a tie, the second election will take place. Candidates who are tied shall be entitled to briefly address council. If the results are once again a tie, then a third election will take place. Candidates who are tied shall be entitled again to briefly address council. If the results are once again a tie, the tie shall be broken by lot in the presence of the 2 scrutineers unless council determines by ordinary resolution to proceed in another manner which may include the holding of a new election. Are there any questions about the process before I begin with the election of the chair? Seeing none, I will proceed to election of the chair. I will begin by calling for nominations for position of chair of the executive committee and council. Vanessa, I see you have your hand up.
Yes, I'd like to nominate Michelle.
Michelle Atkinson. And Michelle, do you accept the nomination to serve as chair?
I do. Thank you.
Thank you. Are there any other nominations for chair of the executive committee? I'll ask for a second time. Are there any other nominations for chair? And I'll ask a third and final time. Are there any other nominations for chair? Seeing no other nominations, nominations are closed for the position of chair. And Michelle Atkinson is acclaimed as chair for 2026.
Thank you.
And Michelle, would you like to briefly address council?
Sure. I am happy to return as chair. I think it's going to be a good, exciting year. We've got a lot of things on the go, and I look forward to moving the needle forward with our strategic plan. And I think it's going to be another year of growth for CDHO, and I'm really happy to be a part of it with all of you. So thank you.
I'll now move to the election of the vice chair. Are there any nominations for the position of vice chair? Jennifer Cooper, I see you have your hand up.
Thanks, Glenn. I would like to nominate Vanessa Pereira for vice chair, please.
Thank you. And Vanessa, do you accept that nomination?
I do.
Thank you. Are there any other nominations for vice chair? I'll ask for a second time. Are there any other nominations for vice chair? And a third and final time, are there any nominations for vice chair? Any further nominations for vice chair? Seeing none, I declare the nominations are closed for the position of vice chair. And Vanessa Pereira is acclaimed as vice chair for 2026. Congratulations, Vanessa. Vanessa, did you want to say anything to council before we move on? If not required.
I just want to thank you all for your support, and I look forward to furthering the public interest work that we do just as part of council and on the executive. Thank you.
Thank you. All right, well, we'll now move on to the election of members at large. And given that we have two members of the profession occupying the chair and vice chair position, we will now need one more member of the profession to sit as a member of large on the executive committee. So I will proceed with that and that election. We'll start with a nomination for the remaining professional member to the executive committee. Are there any nominations for this position? Professional member to the executive committee. Are there any nominations for the position of professional member to the executive committee? Vanessa.
I'd like to nominate Jennifer Cooper.
Jennifer Cooper, thank you. And Jennifer, do you accept this nomination?
I do, thank you.
Great, thank you. Are there any other nominations for this position? And I'll ask again, second or third time. Second time, are there any other nominations for this position of professional member on the executive committee? And a third and final time, are there any other nominations for this position? Seeing no other nominations, I declare nominations closed and declare Jennifer Cooper is acclaimed as member of the executive committee for 2026. Congratulations. Jennifer, you can have some time to say something if you'd like.
Sure, I say thank you very much for the nomination and for your support, and I look forward to learning a new role on exec this year.
Great. Thank you. Moving along, executive committee member at large, number 2. So we have now 2 positions left, both of which will be filled by public appointees. So I'll start with nominations for the first remaining position that will be filled by a public member to the executive committee. Are there any nominations for this position? Aaron.
Sorry, I couldn't figure out the hand raise. I'd like to nominate Amit Sethi for as the public member.
Thank you. And Emmett, do you accept this nomination? Where are you? I can see it. There you are. Emmett, will you accept the nomination?
All right, can you hear me?
Now I can hear you.
All right, yes, I do.
Okay, thank you. And for this particular position, are there any other nominations? Asking a second time, are there any other nominations for this particular position on the executive committee? And a third and final time, are there any other nominations for this position? Hearing none, I'll declare nominations are closed. And declare Emmett Sethi is acclaimed as a member of the Executive Committee for 2026. Emmett, would you like to address council?
Thank you, Glenn, and thank you for the council. And I look forward to the second year as executive member. Thank you.
Thank you. And then so we have one position left to fill by a public member on the executive committee. Are there any nominations for this position? Public member to the executive committee. Emmett.
I nominate Erin Betts.
I think Erin's ineligible because her term will be ending this year. Am I correct in that, Erin?
I don't know if I'm ineligible under the terms of reference because I have not served 3 years. I think I've only served 2 years, but I think practically speaking, it's the will of council, I think. Yes, my term is ending in August, so I guess I think in theory, Julie can correct me if I'm wrong. I think I could serve until I'm no longer on council, and then there would have to be another election of the public members. So if there's somebody else, just practically speaking, it may be make more sense to have the continuity of a public member who can stay on for the entire year.
I think you're right. I misspoke by saying that you are eligible for, I guess, to sit on the executive committee for the remainder of your term. But
for that reason, I will I guess decline at first instance, because if somebody else that's a public member would be willing to serve, and if then I think that makes some good sense. On the other hand, obviously, I don't want executive not to be constituted. So it's the will of council to have someone for 8 months. I would be willing to step in.
Okay. Jennifer.
I'd like to nominate Jenny Jovanoff.
Jenny Jovanoff. Do you accept this nomination to serve on the executive committee?
I do accept. Thank you.
Thank you. So I'm going to, just for clarity, I'm going to accept this as a single nomination for this position because Erin has declined. Are there any other nominations for this position on the executive committee? And I'll ask a third and final time, are there any other nominations for this position on the executive committee? Here, seeing none, nominations are now closed, and Jenny Jovanoff is acclaimed as a member of the executive committee for 2026. Jenny, would you like to say anything to council?
Just thank you. I'm excited to be serving in this capacity for the first time. Thank you very much.
And Madam Chair, I'll turn the meeting back over to you.
Thank you so much, Glenn. So, like I said, I look forward to working with everyone again, and congratulations to my fellow executive members. So, yeah, hopefully we have another great year in 2026, and we continue our good work of public protection. So, carrying on with our meeting, we are a little ahead of schedule, which that's never a bad thing, I think. So I think we could move to agenda item 5.0. I don't think anyone's ready for another break yet. So we'll move to our board education and our council orientation. So I'd like to invite Julie McCura to provide us with our council orientation for 2026. Julie has practiced administrative law with an emphasis on professional regulation for over 30 years. She acts as general counsel, prosecutor, and independent legal counsel for numerous Ontario regulators. Julie's general counsel work includes training specific to the needs of statutory committees, guidance to regulators on registration and quality assurance matters, as well as drafting regulations, bylaws, standards, and policies. Julie has also performed comprehensive legal audits of various statutory programs and processes for regulators and has experience with strategic planning. Julie has appeared in all levels of court in Ontario, representing the interests of regulators on appeals and judicial review applications. We look forward to your presentation, Julie.
Thank you so much, Michelle. So let me just see if I can get my slides to share. Yes, I can. So I'll start there, and then with one more click, you should be able to see not flowers, but actually slides. Yeah, awesome. Okay, so feel free to ask questions at any time during my discussion. I think I'm going to talk for about an hour and a half. So if you need a break at partway through, Michelle, just give me the whatever the signal is for a break. Stop talking, Julie, whatever the appropriate one is. So feel free, again, ask questions at any time. So we'll talk really sort of try to do it like a fundamental orientation, but knowing that we've only got an hour and a half. So we'll talk a little bit of context, governance. I know that we did sort of a deeper dive in governance last year, but I know that you've got some new members of council, so it's always helpful to have a refresher for them. Talk about fiduciary duties, conflict of interest, and this time I'm going to add a few recent cases that might be of interest to council as well to hear about. So I always think that it's helpful to set the context of the discussion and about the work that you do, because especially for those of you who are new to council, regulatory bodies are really an interesting creature. They're unlike any other sort of corporation. They are a corporation, but it's created by a statute. So the Ontario government has delegated to the college the ability and the authority to govern the profession. And so because of that, all of your authority, whether it's council or committee, comes from the enabling statute, which in your case is the Dental Hygiene Act, which incorporates the Regulated Health Professions Act and the Health Professions Procedural Code as part of them. So it's an umbrella statute. The RHPA and the code applies to all the 21 or 22, or I can never remember the number, professions who are governed by it. So midwives, dentists, doctors, dental hygienists, massage therapists, for example. So in section 3 of the code, it lists the objects or essentially the things that the college must do, like set standards for the profession, entry to practice standards, have a discipline program. But at the end of section 3, it sort of provides the overarching object, which says you do all of those things in the interest of the public. And so you don't do them in the interest of the profession. And that sometimes is confusing, especially for people who perhaps have been active in the professional association, like the lobbying organization or the advocacy organization for the profession. That's a different role. It's an important role, but it's a different entity that does that. So that said, public interest isn't defined in the statute, but we can figure out where to look to sort of determine what the public interest is when you're making a decision. So first of all, it's going to depend on the particular circumstances at issue, and it's also going to depend to some extent on the perspective of the audience. So the perspective of a complainant about a registrant is going to be different than the perspective of the Toronto Star or the Minister of Health. The perspectives all might be in the public interest, but they'll have a slightly different lens depending on the particular circumstance. So to determine what the public interest is when you're making a decision, you want to start again, because you're a statutory entity, with the enabling legislation. So again, delegated to you by the Ontario government. So we'd look at section 3 of the code, the different objects that you have, like do you have the authority to do what it is you want to do? And you also look at some of the really overarching themes of the Regulated Health Professions Act, including trying to eradicate sexual abuse of patients. So that's one of the primary ones. Luckily, your profession doesn't have a large problem with sexual abuse of patients. Other professions do. It's still an ongoing problem for a number of professions. Transparency, you can see as well in the code, is a theme of the RHPA, as well as quality assurance, like an ongoing quality assurance program, which is different from the precursor to the Regulated Health Professions Act, which was the Health Disciplines Act, which really did not have any really robust quality assurance or continuing education program. And some professions still don't. I mean, Erin and I know that the obligations for lawyers is relatively less robust than the quality assurance obligations for dental hygienists or any of the RHPA colleges. So some professions have some work to do catching up with that in that regard. But that's one of the themes of the Regulated Health Professions Act. So you can look to the RHPA for guidance about whether your decision that you're about to make is in the public interest. You can also look at, because we live in a common law jurisdiction, we have to pay attention to what the courts tell us about the work that you do, because the type of work that you're doing is administrative law, whether you knew it or not, particularly when you sit on statutory committees like the Inquiries, Complaints and Reports Committee, or Discipline, or Fitness to Practice. That's administrative law that you're doing. But even the work that you do on council, when you're making decisions that impact registrants, that's administrative law. And courts will review the decisions you make to make sure that they're reasonable, to make sure that they're in compliance with the Charter of Rights, for example. So you look at court cases, what the courts say, not just about what your particular college does, but really about any RHPA college, because they're under the same umbrella statute, and even colleges that are not. So for example, the College of Teachers, there's lots of law about the discipline outcomes at the College of Teachers. You need to pay attention to that, because the principles that apply from that statute are very, very similar to what's in the RHPA. And we even need to pay attention to what the courts say, for example, the Supreme Court, if there was a decision about a British Columbia regulator, you need to pay attention, because that guidance is binding on the work that you do. So in addition to the act itself and the decisions of courts, you want to look at commissions, inquiries, task forces. So the Sexual Abuse Task Force, there's been 3 different ones now in Ontario, and every time there is one, there are amendments to the RHPA as a result of that, because sexual abuse of patients has not yet been eradicated. So you want to pay attention to those kinds of things where, let's say, Harry Caton and Deanna Williams do a review of a regulator like yours. Other colleges would look to that review, even though it was a review of your governance work, to get guidance from it, because those are folks who've been around and doing this work for many years, who know what the public interest is. So those are places that you can look for guidance as to whether one of your decisions that you're about to make is in the public interest. So the questions that you could ask yourself: does it relate to our objects when you're about to make a decision? And again, you would go to Section 3 of the code. Does it further one of our regulatory activities? And those regulatory activities can be described as restrictive, which are the entry to practice, essentially, should someone be registered; reactive, which is the complaints and discipline process; proactive, which is quality assurance, is actually trying to bring the entire profession sort of up, not just have everybody at the minimum standard; and also, is it being done transparently? So those are sort of the 4 core regulatory activities. Is it being done transparently or in secret? It shouldn't be done in secret, the decisions that you make. They should be open to scrutiny by all of the system partners. Who's the primary beneficiary? If it's the profession, then the decision is probably not one that's in the public interest. Would this better fit under, let's say, the mandate of the professional association, or an employer, or the Ministry of Health? Who's going to be unhappy with the decision, and why? How would it look on the front page of I always say Toronto Star, because they're the ones most interested in regulatory work? And how would your accountability bodies respond? And those include the courts, Divisional Court, which hears appeals from discipline hearings; the Health Professions Appeal and Review Board, which is a standalone, separate, arm's length entity from RHPA colleges that hear appeals from complaints decisions from the ICRC and from registration decisions. So how would they respond? As well, the Fairness Commissioner, that looks at the registration process and systems that for all of the colleges. So that's sort of the public lens. Public interest lens has to essentially permeate everything that you do at the college. So that's just a little bit about the context. So we'll move to governance. And again, governance is one of those things that you'll hear referenced a lot, but it's not defined in the act itself. But it can be described as really the process or system in place that is aimed at making sure that there's effective direction and supervision and accountability for the college. So good governance is not something that you just do every January and you check the box and say, we're good to go. It's a process that requires ongoing renewal and revision. And the type of governance system that you use can change over time. And this college has recently moved away from policy governance to more sort of strategic management and working in partnership with the registrar, and we'll talk a little bit about the changes in that way. But it really is something that you need to continually monitor and improve over time. It's not because good governance is a goal in and of itself, but it's because it allows you to achieve the things that you want to achieve. And as well, the expectations of system partners change over time. So the expectations of the Ministry of Health change over time. And we saw that recently, a number of years ago now, but with the implementation of the CPMF, the college framework, I know it's the acronym CP, College Performance Framework. And those expectations from the ministry trying to make the work of these many different colleges more consistent so that members of the public will know that, okay, what this college is doing should be similar to this college because the expectations of the ministry are more apparent. So again, the goals of good governance really are to try to make sure that there's consensus on important decisions. Consensus doesn't mean unanimity, but that the majority of council is behind a particular decision. Good governance also helps to make sure that your mission, goals, and strategies are well thought out, and they're not just sort of, you're not flipping a coin. Of course, the mission, goals, and strategies are really limited to some extent by the RHPA. You can't decide that we want to, buy some land in the Bahamas. That's just not within the parameters of the work that you're going to do and that the RHPA says that you must do. So even if you didn't want to spend a lot of money on discipline, tough, right? The RHPA says you must. So if you have some rogue registrants, you have a very expensive discipline hearing, you must still hold that hearing and spend that money and take that time because that's one of the fundamental programs that the RHPA says that you have to offer. Good governance also helps you be focused and ideally effective. It also helps you retain good talent, both on council and staff. Even though there are 26 different colleges or 20 however many, people know which college is effective, which college's council is toxic, which college's council is disorganized, and staff will move if there is not good governance in place. So good governance is going to let you use that available talent. And that was one of the, I think, takeaways of the review that Harry Caton and Deanna Williams did of the social workers a number of years ago, was that to use the available talent you have. So instead of constantly striking task forces, to use the talent and the expertise that you have on staff, because your staff are experts in regulating. A lot of you might be experts in dental hygiene, those of you who are professional members, but might not yet be an expert in governance, in regulatory work. So the philosophy of the governance sort of philosophy that should be driving the work that you do goes back to that public interest mandate that's set out in the code. You are a public interest body. So good governance in place will help to prevent regulatory failures that we see across the country. Some years ago in BC, the dental surgeons there, completely toxic council. They were spending more money on and fighting amongst themselves than they were on essentially regulating the profession. And after a review again by Harry Caton, the ministry said, this is ridiculous. We're going to overhaul this whole system, change it. And that impacted other professions as well. There's now umbrella legislation there, and a lot of amalgamation has happened. So at the end of the day, you have to remember that it's not granted by some higher power. The higher power is the Ontario government that could take away self-regulation or modified self-regulation that you have. So the model that all of the RHPA colleges are using is essentially a trustee model. You're working on behalf of the public. You're stewards for the public interest. It's not when a professional member is elected to council, you don't represent the district that elected you. That's just a way to get geographic representation on council. We can see as well the critical role that public members play, getting closer and closer to being 50%. I think in BC now, it is 50% councillors are public members. And you can also see that in the amalgamation that is happening in British Columbia, if the council is only 8 people and half of them are public, and you're regulating 6 different professions, you've only got 1 member of a profession on each council. And so and some councils are getting away, and I think in the future it's really going to be that it might entirely be members of public on the council, and that the committees are the ones that have representation from the profession, because that's where you have the subject matter specialty expertise that you need. Really, the work of a council is more strategic and ensuring that the goals of the RHPA are met. We can also see in court cases that the impetus on the work of public members, a case from the College of Chiropractors a number of years ago, the court was very impressed by the fact that the public members on council voted overwhelmingly for this particular bylaw change, which was unappealing to at least 1 member of the profession. But the court said, we can see that it's in the public interest, because, in our view, because all of the public members on council voted for it. So the philosophy as well should be that the relationship with the registrar is a crucial one. And we can see when there's regulatory failures across the country is when there's a sort of a lack of trust between the registrar and the council. And so it's really not just a top-down sort of you, the council, telling the registrar what you want to happen. It's important that you listen to the registrar who's involved in the day-to-day operations and who's aware of trends and issues happening, and that it's a constant sort of back and forth between council and the registrar. So really, ideally, no surprises. It's all about transparency. People should not be bringing personal agendas to their role in council. It's about an open dialogue, not conflict of interest, and we'll talk more about that. Instead, objectivity. Respect is paramount, and there shouldn't be politicking. There shouldn't be behind the scenes sort of, hey, if you vote for this, then I'll vote for this that I know that you're interested in. Really should be open debate, and debate that happens around the council table. I've seen some other councils, and this used to be in the past, it was probably more likely, but they would go in camera whenever they wanted to debate a difficult decision. And that's not good governance. And that's not what a public interest body should do. And now the RHPA and the Ministry of Health has gotten a lot more invested in ensuring that councils only go in camera when they're permitted to by the RHPA, such as dealing with a personnel matter, because the reasons that you can go in camera are set out in the code itself. So I think the 4 E's of good governance could be just in terms of the roles that everyone in the organization plays: an explanation, education, evaluation, and enforcement. So explanation, there really should be a clear written description of the mandate and the responsibilities of each entity within the college. Every education, every person involved in the direction and the operations of the college should be oriented to their mandate and their responsibilities, and they have to understand how they relate to the other entities within the organization. Evaluation, every entity should be accountable for their activities, should report on what they've done and receive feedback on their performance. And then role enforcement, where a person or an entity, or whether it's a committee within the organization, is not, in fact, participating appropriately in the college's work, then, despite having the role explained to them and despite appropriate education and evaluation, then there has to be some means of enforcing the organization's expectations. And you've got a code of conduct that Michelle mentioned at the very beginning of the meeting today. So the guiding principles really should be focusing on the public interest. Council leads and directs, particularly when we're talking about strategic initiatives, not operations, and we'll get into the differences there. But recognizing that the registrar has a unique role, not just as CEO, but there are certain things that the RHPA says only the registrar can do, which is appoint investigators, for example, or refer applications to the registration committee. So you can see the unique role that the registrar has in an RHPA college as opposed to any other type of corporation. Statutory decisions of committees, such as ICRC, registration, discipline, those are independent of council. Council as a whole is not entitled to know why a committee made a decision. It's the committee's decision, written decision, speaks for itself. And just because you're on council, you're not entitled to know why a particular decision was made. As well, individual council members don't have authority. Your authority comes from council's decisions as a whole. Once decisions are made, council should support those. If you cannot support an important decision, really the only way to comply with your fiduciary duty is essentially to resign from council if it's a crucial decision and you cannot support it. And the chair's role is not that they have some special and more power than other individual council members. It's that their role is to facilitate discussions around the council table and coordinate the work of council to make sure that the appropriate items are on the agenda, items of risk that essentially warrant the important and scarce time of council. So you probably have heard, at least me, say this before, but if council were a ship, if the college was a ship, council is the entity that steers it, and the staff is the entity that essentially rows it. So in terms of steering, it should be that through leadership, through your tone, through using integrity, diligence, and questions, and those go to your fiduciary obligations. Providing financial oversight, other oversight to the work of the college, setting strategy and direction and policies, again, constrained somewhat by the RHPA, but risk management is becoming a more and more crucial part of the work that council does, so that you're not just you on your own, but with the registrar, helping to identify risk to the college and also risks to the public from your registrants, helping to assess the risk, treat it, and monitor it. And the work of council really is particularly about reputational risk. So in terms of general principles, again, the board sets strategic direction, but it doesn't implement the decisions once those are made. The registrar and staff implement your strategic direction decisions. With respect to, again, sort of strategic directions, the registrar and CEO can propose, can advise, and administers, but the registrar does not make those strategic direction decisions. With respect to operational matters, yes, the registrar does make those decisions. Consultants, whether they're lawyers or accountants, they can give you advice, but they don't make decisions. We simply say, here are the options, and here are what I think are the most reasonable options, and here are the pros and cons of all of those decisions. So registrants and other system partners can make submissions when you're about to make a decision that might impact, for example, registrants, but they don't get to decide. They simply can make submissions, and that's when you're, for example, making bylaws or regulations. You send them out for consultation. Likely you do that with standards as well, and you get the feedback, and you consider the feedback of the profession, but it doesn't bind you. Essentially, sometimes the profession doesn't like a decision you're going to make because it's going to be essentially more work for them if you were going to make your QA program more robust, for example, but you would ultimately decide whether it's in the public interest. So I think the last time that we had this discussion, probably a year ago, we were you were making that decision to change from policy governance. So we did talk a little bit about dashboards. And so this I'm going to discuss right now about operational matters. So the use of dashboards when you're talking about operational matters. So with those matters, you provide a high level of oversight to the registrar. That is, you don't get into the details. You don't start to micromanage what are the office hours? What days do staff have to be in the office? That's not the level of oversight for operational matters. So the optimal level of reporting on those matters really can come through things like dashboards, graphs, tables, charts, so that you can see easily what's happening, what the trends are. And your council package is full of charts, tables, graphs that provide really valuable easy to access information to you. And we know that you already have a dashboard for patient experience and registration experience. And we saw at the December council meeting that you're developing a risk management dashboard that I think is almost ready. And also the CPMF has appendices containing sort of useful dashboards, and comparing those, the council should compare those dashboards over time and even as against other similar regulators to see how you're doing. That can provide a lot of information, as long as the information is like you're comparing apples to apples, because some colleges count, for example, let's say the days of how long an investigation takes. They might count the start of it differently. So you'd have to make sure you're comparing apples to apples. So really the role of council with respect to operational matters is to identify warning signs from the information that you're given and ask the appropriate questions of the registrar. And so 3 important questions to ask might be, if you see a trend happening, what's happening? There might be an innocent explanation. Let's say there's a really unusual long discipline case that is skewing statistics, whether it's skewing statistics about the cost for that particular department or the length of time to finalize, outcomes. The second question will be, what's your plan? What do the registrar, do you have a plan in place? And if the registrar does, you would show deference to that plan. You'd only intervene if the plan was obviously inadequate. And the last question will be, how can we help? Like, do we need more resources? Do we allocate resources differently in light of this particular issue that's happening? So those are the 3 sort of helpful questions that you would ask in relation to operational matters. So then there are different types of dashboards, and really it's really just limited probably by your imagination. But the common types used for boards of directors include these ones listed on this slide. So strategic dashboards would provide sort of a concise, high-level overview of the organization's sort of overall health and progress towards its long-term goals and strategic objectives. And so they focus on key performance indicators rather than on sort of granular details. Financial dashboards, crucial, of course, for monitoring the college's financial health, and those dashboards would track important metrics like surplus, deficits, cash flow, reserves, and they help you identify financial problems and ideally would drive proactive decisions about the financial health of an organization. Risk and compliance dashboards, so those would sort of aggregate information on organizational risk management, including things like cybersecurity, what's the chance of us getting hacked, compliance status, to help you identify sort of threats and ensure that you're adhering to your regulatory obligations. And statutory regulators might also have dashboards assessing risk to the public from the activities of their registrants. Environmental, social, and governance, those kinds of dashboards track progress on social responsibility goals, on enhancing transparency, on system partner trust. Operational dashboards, again, for the work of a board, those will be at a high level. And they would typically focus on daily activities for management's purposes, but a board of director might use a high-level version to monitor sort of significant operational efficiency, processes. Analytical dashboards, these are more sort of for deep dives by analysts or senior management to uncover trends and patterns where they really think that detailed investigation is needed for informed decision-making. So after sort of reviewing what those dashboards really look like and mean and deal with, what do you think are the most important dashboards for the board of a statutory regulator to have, and why do you think that's the case? And there are no wrong answers. This is a safe space. Any thoughts about what you would find to be most helpful or most important for a board? Vanessa.
I think the strategic one would be, I'm seeing a lot, but I'm going to go with strategic first because it's important for us to see whether or not the college is meeting those, meeting those strategic, what's the word? This going forth with the strategic plan.
Yeah, like the goals and the strategies and objectives. Yeah.
Thank you.
Michelle?
I think all of them, but for sure financial and risk would be important.
Okay. Anybody else think otherwise? Does anybody else say, no, 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 I think I really want to know what Glenn and his team are doing. I think operational is the most important. Or was there sort of consensus that you think really the first three are the important ones, the most important? Nobody disagreeing? So yeah, I mean, there's no right answer. And of course, it's one of those things that it's all about the information that's within the dashboard, right? Like you can look at these from a technical perspective and say, yes, this looks really good. But if the sort of underpinning theory of what it is you're focusing on is wrong, the dashboards are not going to be helpful. Like if your strategic direction is skewed, and in fact, the work you're doing is benefiting the profession and not the public, then these don't really mean much. So it's assuming that the work that you're doing is actually, doing the right kind of work, which probably goes to risk and compliance and strategic. And of course, financial, obviously, like you need to know that there's enough money. But again, you might be in a really good financial position, but you're not actually getting through any complaints. You're only processing one complaint a year. That would be a mismatch. But I think assuming that you're focusing on the right things, which is part and parcel of working hand in hand with the registrar, these kinds of dashboards can be quite helpful. So let's move to like just an operational scenario. So there's a regulation under the RHPA that requires the registrar, and this is real. I haven't made this one up. That requires the registrar to actually acknowledge receipt of an application for registration within 15 days of the person applying, and either accept it and register the person, or refer it to the registration committee within 15 days of receiving all of the required information. So if the person hasn't actually, filled out or provided the proof that they have a degree, then the 15 days doesn't count until you have all the information. So let's assume that dashboards show that this requirement, the 15 days requirement, in 2023 was met 80% of the time. In 2024, it was met 60% of the time. And in 2025, it was met 40% of the time. What do you think council should do with that information? Knowing that's an obligation, so it's a legal obligation that the ministry has put on all of the colleges by way of a regulation under the RHPA. Any thoughts?
I think, like you said, we need to ask what is happening. Why is this trend showing this way?
Yeah, so that would be the first one.
Yeah.
The first thing, ask, and there might be a rationale. Vanessa?
And then I think the second thing would be, what's your plan to address this?
Yep. And then the third thing is, what can we do to help, right? So this is not the time, though, to sort of blame the registrar and say, like, oh my God, you didn't meet your performance this year, not good because of this. You need to actually try to sort out what the problem is and figure out how to impact it. So you should be asking for reports on why this is happening, the significance of this, like what does this mean, in terms of, like, we can see, obviously it means that it's taking longer for people to get registered, but what's the significance of it and what are the possible solutions? And I mean, if staff are unable to provide the information, then you might retain an external consultant to review. Likely staff could provide the information though. But then once you have that information, you would need to assess the degree of risk. And so the risk in this place is that you're going to get, your knuckles rapped by the Ministry of Health or the Fairness Commissioner for not complying with this, or you're going to get yelled at by registrants who know that this is an obligation. And what resources are needed to reverse the trend, assuming it is a significant risk. So it's the board's job really to make sure that the resources are available to achieve your obligations. So not just your objectives, but some of your obligations, which are imposed on you by the government through the legislation. So in terms of operations, we all recognize and acknowledge that it is hard to balance the duty of effective council oversight with the need for staff to be free from interference while they're performing their duties. So because you have an obligation to prevent regulatory or other failures from happening. So, you have an obligation if there was a staff member who was, let's say, sexually harassing most of the staff at the CDHO and the registrar wasn't paying attention to that, you as council would have an obligation to do something about that. But assuming that it's not that kind of a big sort of serious regulatory failure, generally, council is not involved in the day-to-day operations because you don't have the skills to do that. And at every college, staff will essentially leave if they're being micromanaged. So what's crucial to make sure that everyone is doing the job that they're supposed to do is to clarify with the registrar who does what, right? And so clarifying who sets strategic direction, who's taking care of this particular issue. So making sure that each entity in the college is doing what they're supposed to do, it will help prevent you, not prevent's not the right word, but you know what I mean? Like not get into operations unnecessarily. So you're responsible to make decisions relating to governing the college, such as the governance model that's chosen, the organizational mission, and your strategic goals, again, limited by the RHPA. And then you monitor how those goals are being achieved. But purely administrative issues like banking arrangements, payroll administration, those are established by the registrar, and they should not be discussed on the board agenda. Those simply don't warrant the time, the scarce time that the board in terms of a meeting. So that said, as compared to dealing with operational matters of the college, your role is different when you are issuing or amending guidance to the profession by way of regulations, bylaws, standards. So, and for the purposes of this slide, I'm going to probably I'll refer to these as policy matters. And I know that sometimes can be confusing because you're used to use policy governance. So I'm using it the term the way that courts describe it when they really are talking about when you're making decisions that impact the profession. So whether those are standards or bylaws. So when the courts are discussing regulatory policy, that's really what they're talking about. So when the decision that you're about to make relates to advice or guidance to the profession, then the role of the who does what is a little bit different. College staff and consultants can give you advice, they can recommend things, but council is the entity that decides. And so because of that, you have to make sure that you have enough information to make a decision. You need to analyze the information you're given, and then you need to make the decision. But then once you've made it, explain what the rationale is for the decision that you ultimately make, including the factors that are listed at the bottom of this slide. So the public interest, risk management principles, right touch regulation. And you also need to consider, and this is the Supreme Court is telling us this more and more, you have to consider and balance competing interests, such as freedom of expression rights of your members. So for example, if you had a policy about social media use, you've got to consider the charter freedom of expression rights. So that there's a balancing that has to be done there. And you need to make sure that you have the legal authority to actually make the bylaw or standard, which you would find in the Health Professions Procedural Code. So briefing notes that you get at council and in your packages, those are used to identify the issues that you need to address. They'll ideally describe the outcome of the research or the work that was conducted. They'll articulate the available options, summarize the results of any consultation that happened, set out the advantages and disadvantages of the options, possibly make a recommendation, propose an implementation plan, and then specify, ideally, the method for monitoring and reviewing the impact of the policy. So, of course, making policy and making decisions and guidance to the profession is important, but you want to also monitor that policy to see if it's in fact having the outcome and the impact that you are hoping that it's going to have. And as well, briefing notes recently have gained more importance in terms of a board's risk management and governance functions. And so the briefing notes also should identify that the topic is a risk that's worth addressing. Like it's serious enough that council should be spending its time and doing this. This goes back to right touch regulation and right touch response. So the analysis portion of the briefing note would sort of evaluate the nature of the risk to help you understand it better. What's its root cause and what's the impact of existing measures? Like you've already got some measures in place. What are the impact of those to reduce the risk? Also important in a briefing note is a review of the possible additional measures to address the risk, including the potential unintended consequences of each of those options. And again, that's where right touch regulation is important. And of course, briefing notes help regulators become more transparent in the work that they do. And certainly, I've been doing this work for about 32 years now, and I know I don't look a day over, I don't know, 61. So the briefing notes that I used to see when I was first called to the bar and doing this work are very different from the ones now. They were very bare bones before, and it would be really difficult for the profession to understand the rationale for some of those decisions that were made 30 years ago, as compared to now, where the notes are very fulsome. And I mean, there's, I always say my motto is better has no limits. You can always improve, but they already have improved a great deal from where they were 10, 15, 20 years ago. But in addition to all of that, briefing notes also have an important legal role, because the Supreme Court of Canada has said that subordinate legislation, including policies, so subordinate means sort of like, so that the acts are at the top of the pyramid, then there's regulations, then there's bylaws, and then there's standards. So the law, including standards that is sort of subordinate to the act, has to be reasonably authorized by your enabling legislation. So in your case, the RHPA, the Dental Hygiene Act, and the Code. And so the Supreme Court has signaled a slightly less deferential approach by courts when reviewing administrative policy decisions that bodies like regulators make. So to address that, to try to make sure that your bylaws and regulations and standards are upheld if anyone challenges them, you should make sure that any proposed changes that you're making are accompanied by a briefing note that explains the purpose and the goals of the proposal or the amendment, explains its relation to the objects in the RHPA and the Code, and also the research and the analysis behind the proposal. So a really well-drafted briefing note can also provide strong evidence that the decision that you're making is consistent with the RHPA and is also consistent with charter values. And so that's something else the Supreme Court has also said has to be considered when the state, the government and quasi-government or agents of the government, like regulatory bodies, have to consider when they're making discretionary decisions, like bylaws, regulations, guidelines, and standards. So any questions before I move to sort of issues relating more to specifically to individual council members? No? And Michelle, you let me know if we need a break, if you want to break at any point. Yeah. Okay. No questions? Okay. So in terms of the role of individual council members, you don't have any, none. You have no role independent of council. Individual council members cannot act on their own. Your role instead is to participate in council and committee deliberations and, council speaking with one voice. Your fiduciary obligations, which we'll get into next, undivided loyalty and diligence to the college's mandate, which again is a public interest mandate. And again, the constituency model, i.e. that if when you're on council, you represent District 10 or District 12, does not apply. You are simply, once those districts are really just a way to get geographic representation, but once you're on council, you represent the public interest and the college's interest. So your fiduciary duties are to act honestly in good faith to the best interests of the college. So you've got a duty of loyalty. You have an obligation to avoid conflicts of interest. And you've got robust confidentiality obligations that are imposed and that last even after you go on council. So you can't start talking about these things after that you learn through your work on the college after you leave council. And council members also should be engaging with each other respectfully, actively participating in meetings and with collegiality. The standard of care that is sort of like, how well do you have to do these things? It's really the care, diligence, and skill that a reasonably prudent person would exercise in comparable circumstances. So I think that's helpful to you. You're not expected to be experts, not expected to be perfect. And there are robust immunity provisions in the code if you're making decisions in good faith. But essentially, you should be taking these fiduciary obligations very seriously, because if you were found to be acting in bad faith, the immunity provisions would not protect you. So the obligation of diligence means that you prepare for meetings, and regulators can tell when a council member has opened the package the morning of the meeting, which means you are not meeting your fiduciary obligations, and which also means that there's no way you could meaningfully participate in the discussion if a member has opened the package the day of, if it's a 500-page package. Preparing for meetings means reviewing the materials, identifying anything that's missing, considering the issues, perhaps even coming to a preliminary view of how you might vote, but not making a firm decision. That would be not complying with your obligation in the next slide, which I'll talk about, which is having an open mind to the rest of the debate at council. You need to arrive on time. Don't cancel late, particularly for committee meetings. Of course, sometimes that will impact quorum. Participate in the discussion to allow that, like, all reasonable perspectives being articulated. Make sure that you vote. My view is that abstaining from voting means that the system isn't working. And if you've given any tasks to do, that you follow up on those in a diligent and prompt way. So the obligation of respect, not just to treat each other respectfully, but that also includes the obligation to not make up your mind and not have a closed mind before you arrive at council. You respect the rest of council. That means you genuinely listen to and consider the other perspectives around the table. Doesn't mean that you have to agree with everybody before the vote is taken, but after the vote is taken, you have to support it. Again, even if you adamantly opposed it during the deliberation, you need to support it afterwards. And if you can't, and it's a very important decision, really the only way to abide by your fiduciary obligation would be to leave council. That doesn't mean that you can't challenge when there's not enough information to make a decision, or if a council member makes inappropriate comments. In fact, it's an obligation for you to call that out in a respectful way, but to not let it just sort of go by, because the rest of anyone listening will think that council agrees with that kind of discussion. Ethical behavior, the integrity of council members really has to be above reproach. This is where the Toronto Star can easily say, you know, this college is having $10 orange juices when it goes for breakfast. So your expense and compensation claims have to be pristine. You are not using college property or staff to do your own to advance your own purposes. That belongs to the college. If you're going to be absent, you have to be honest about it. You don't want to have the rest of council go on your Instagram page and find out that you're actually on a beach in Costa Rica somewhere. When you said you were sick with COVID, you can't as well try to inappropriately influence decisions. So you should not be approaching other members, whether it's committee or council, to say, hey, I really think that this is that kind of discussion should happen around the table transparently. And as well, it's important to remember that having discussions after a decision is made is also very risky, whether it's a committee or council decision. And ideally, you will defer those kinds of questions to the chair of council or to the registrar. So you have obligations to comply with your fiduciary duties, and that means making sure that you know what they are. So looking at the bylaws, looking at the obligations that are set out there. If you breach your fiduciary obligations, you should be telling, whether it's the chair of the committee or chair of the registrar. If you, let's say, inappropriately breached confidentiality, it's making it worse by not telling the college about that. So if there are breaches, you want to address those appropriately. There will be a fact-gathering process, and the response of council ultimately through the code of conduct process could be some guidance, some education. It could be a formal censure, and it could ultimately be removal from council or recommendation to the public appointment secretariat that a public member be removed after a code of conduct process. So So here's just a scenario dealing with fiduciary obligation. So let's say during a break in a council meeting, you overhear a counselor who happens to also be on ICRC, and they're describing a complaint made against a dental hygienist involving allegations of fraud. And the member of the committee mentions the name of the city and the clinic involved. How do you respond if you're trying to comply with your fiduciary obligations? Any thoughts? And so here are some of the options here. Pretend you didn't hear it. Have a private conversation with them. Report it to the committee staff support. Report it to the chair of the committee, or start a formal code of conduct complaint to the chair of council. Anne-Marie?
I think you would report it to the chair of the committee.
Nella?
Have a private conversation with the person and then report it.
Okay. Yeah, so I mean, the proper, like the response is always going to depend on the circumstances, but I think both of you, I'm inclined to agree with that, is that, first of all, the first option, pretend you didn't hear it, that's not a reasonable one. That's an abdication of your responsibility. So that's really the only not good option on this page. But likely a private conversation with the council member is not enough. So because you don't know if this is an ongoing issue. So that might be a good start, but I tend to agree with both Anne-Marie and Nella that you would likely also report that to the chair of the staff, or a committee, or the chair of council, wherever in this case, it might be both, because it happened at council, but it was a committee discussion. So this, if it's a one-off thing, it's probably going to be just addressed with some education, just some advice and training. If it's an ongoing matter, it might actually, turn into a formal code of conduct with some potentially formal censure at the end of it. But pretending you didn't hear it is the only not good answer on that page. So just very briefly, dealing with committees, we already talked about the fact that statutory committees, especially, essentially all of them, but adjudicative committees like discipline have those are independent of council. Registration and ICRC is not independent in the same way, but there's a high level of accountability for all those activities. And when you're on a statutory committee like registration, fitness to practice, discipline, those committees report to council really just on a statistical basis. Like we had 7 hearings this year, and they took up this many days of hearing time. But those committees don't provide details about why or how the decisions were made with regard to individual registrants. It's really unlike non-statutory committees, such as that support the work of council, like finance committee or the governance committee. Those in fact do report to council. Those support the work of council, but the statutory committees are very, very different. So any questions or comments before we move to conflict of interest? No? And Michelle, again, you think a break, or no, keep going? Okay. So first of all, conflict of interest, it's inevitable, right? Like there's always going to be an instance where there's a conflict of interest arises. So what it is really where you have a competing duty or interest to an extent that a reasonable person looking at it would think that you might be influenced by that competing duty or interest. So having a conflict of interest in and of itself is not a bad thing. You're all very high achieving people involved in a lot of different activities. And so it makes sense that occasionally one of your other duties or interests is going to compete with the work that you do on the college council. But the goal of the rules about conflict of interest are to try to minimize the occurrences of them happening and then manage them when they do occur. And this is really an area of risk for many colleges. It's amazing how we can often see when someone else has a conflict of interest, but it's hard to see it in ourselves sometimes. So in terms of the goal, the minimizing occurrences would be, for example, in your bylaws where it lists reasons why a person could not be on council. So for example, if you're on the board of directors of the professional association, it's written right there that you cannot be on council if you have a high position, with the association, because fundamentally the two roles are incompatible. You would always have a conflict of interest. Whereas some other conflicts, for example, the educators on council, those conflicts might happen when there's a debate around the council table about the educational standards that the college is going to insist on for entry to practice. So that's when those people with a different role have to really think carefully about, should I actually be making a decision here because of the role that I have with this, with the dental hygiene educator. So essentially the rules are you should not be participating in making decisions where a conflict of interest exists, because decisions have to be made only in the public interest without those competing considerations. And the risk of failing to avoid them or manage them are in fact serious. They're serious for the college. They're serious for the individual council member. They can create serious reputational risk for the college, and often it will appear on the front page of the Toronto Star, which it has for a number of colleges, even in the last year or so, of our HPA colleges when they're dealing with conflict matters. So when it happens, and it could happen at any time, so you have to think about the subject matter of the decision or the topic that's being discussed because of my decision somewhere else, or because of my strongly held belief. Should I be involved in this discussion? You have to think of your relationships with other people and other entities and situations. Because of my position, should I be saying this? The types of conflict of interest, financial is the most obvious. It's also the least frequently that happens at colleges. It's unlikely that, for example, if one of you was married to me, you wouldn't be able to be on the around the table when the college is discussing should we retain Steinecker Mercure LeBlanc to provide our advice. So those are relatively infrequent, but they could happen. It could be that your sister-in-law is the provider of certain kind of training, and you would have to recuse yourself from that decision if the college was thinking of retaining that person. So adjudicative, sort of bias issues, we usually describe them as bias rather than conflict when you're, let's say, on discipline. But if the registrant before you, or even an important witness in the hearing, is a good friend of yours, you will have a bias that you're going to have to declare. The educational requirements for the profession, that again, for the members of the profession who are educators and the members on council, you have to think carefully about those. And then the organizational ones, there are certain positions running for provincial government. You can't do that when you're on council, for example. So because they compete with the interests of the college. So you have to put the college's interests ahead of your own, can't have a divided loyalty. And again, very few of the rules are absolute, other than the ones that are right in the bylaws. It's always going to depend on the circumstances. But the important thing to do is, if you're concerned that you might have a conflict of interest, consult with the appropriate person, whether that's the chair of council, the registrar, ideally in advance of the meeting. But worst case, if it happens in the middle of the meeting, you say, I just realized because of this, I perhaps should not be involved in this. If there's any doubt, disclose the issue. And then ultimately, if you don't think you have a conflict, but you are concerned that council might think you do, council or the committee would ultimately deliberate and vote. If you declare a conflict, you need to leave the meeting, not be involved in any sort of deliberation before the vote. And you must not try to attempt to influence the deliberation or the vote before you leave the room. So you can't say, this is the stupidest thing you people have ever thought about doing, but I disagree, so now I'm leaving the room, for whatever reason. So you can't say, I can't, make a decision about Julie Mercure and her firm because I'm her husband, but my God, she's a good lawyer, but I'm going to go now. So you can't, whether it's a positive way or a negative way, you can't try to influence the decision. So what about if you think another member of council has a conflict, or another member of the committee? Again, sort of that with where you saw the confidentiality breach, you have a fiduciary obligation to do something about it. So ideally, you could start with consulting with them, discussing with them, and say, hey, Michelle, did you think about the fact that you also sit on this, or you also have this role? And 9 times out of 10, that's going to result in the person saying, oh my gosh, I hadn't even thought about that. You're right. I shouldn't be involved in this. But if you think that that's not going to happen, then you would approach the chair of council or the chair of the committee, who then is going to likely speak with that person. And again, if the self-declaration didn't happen, then it would be raised at the meeting, and council or committee would ultimately vote as to whether they believe the person was in a conflict or not. So how about a conflict of interest scenario? Council is considering how to enhance the quality assurance program. One option being considered is having council members act as peer circle facilitators. It's proposed that the per diem for this activity would be $300 per session, and that one council member would take the lead on training other facilitators with an additional per diem of $200 per training session. Can you identify any concerns with this particular proposal? No, everybody fine with that? We're good to go? Bump up the rate, maybe? No, I see Michelle. No, okay, Vanessa?
I was hoping someone else would speak up. But there are several concerns. I mean, we can't be changing rules in order to benefit ourselves. That's a huge conflict of interest. I'll stop there and hopefully someone will jump in and add something.
Anybody else?
Yeah, there's definitely conflict of interest issues here. Council members shouldn't have a dual role. So council members make the decision about, approving changes to different things, but they shouldn't be the people doing the things, because they then are benefiting from that decision. So they're going to make the decision to implement this, and they're going to benefit from it.
Okay. And so what if we change the scenario a bit, and let's say you weren't going to get paid at all and you're just going to do it out of the goodness of your heart? Would you still have a problem with this?
Yes.
Vanessa would, yes. And
Yeah.
why, Vanessa?
Because just because you're a council member doesn't mean that you have the necessary skills or knowledge to do the training or to even be a peer facilitator. So yeah.
Yeah, exactly. Yeah. And so that, unfortunately, I have seen that in the past at some councils, not at this council, but there's sometimes an assumption that council members have the knowledge and skills to perform the function, and it doesn't necessarily mean that. There are different skills needed for different things, whether that's on council or even on committees. So certainly this is a conflict of interest scenario. But also an assumption that the council members have the knowledge and skill to perform it. So absolutely. So how about another one? During a chat with Jane Doe, who's a public member of council, you learn that she has just been appointed to a Royal College of Dental Surgeons of Ontario task force looking into governance reform. Jane feels she can contribute because of the work she has done with CDHO. Do you have any concerns about this? And if so, what do you think should happen? Maybe we can try to hear from somebody who hasn't spoken yet. Safe place, no wrong answers. Any thoughts? Bueller? Nella?
I don't feel that she should be discussing anything that happened on the CDHO member or council. She could take the knowledge of what she has, but she can't be discussing. Maybe I'm saying it wrong.
No, I think I know what you're saying, but you think that you think it would be okay for her to do this, to take
I don't think she should be on both committees or at all at the same time.
Okay. Does anybody think that she should be able to do it? Christina?
I think in this case, it's really about transparency. Like, I think if both, usually they don't want you to be on, conflicting, like within the healthcare regulation, usually you're just sort of tied to one, we'll say. So I think it'd be unusual for a public member to have to do this, but I think in this case, it's really about transparency, like going to the chair and saying, I've been offered this, and sort of full disclosure on it. I think the only part that doesn't sit right is because of the work she's done with CDHO. Well, yes, that's given experience, but to Nella's point, you don't want to use information that you obtained in confidence potentially, but it's a skill. I guess the concerns are more of like maybe there's a conflict, but I think it's about transparency, and both organizations should be aware of, can you hold both roles? And I think in this case, you'd probably go back to the ministry to weigh in on if there's a conflict, as opposed to the member themselves making that decision.
Yeah, no, I agree completely. So there could be conflicts of interest arising here, but really, theoretically, if Jane had originally like brought it up to CDHO and said, I've been approached by the RCDSO, do you think this is okay? Council could have decided, you know what, that will be okay. The thing, though, is that that's the technical legal term. The thing, though, is that because she sits on council, she's got a fiduciary obligation to CDHO council. So she's going to have to report back about what is happening at RCDSO. So that's probably going to be a deal breaker for the RCDSO. So I think it goes back to the transparency piece. And that if both colleges were okay with her being transparent with both of them and sharing that information, it might be okay, but it's not the kind of thing that she'd want to just make the decision herself, that she's determined it's fine for me to do this. So I think you both got it bang on. So thank you. So I already talked a little bit about appearance of bias. It's just kind of a type of conflict of interest, but it more applies to adjudicative decisions. So it's about if you prejudge a matter before you've made a decision, if you have a connection to a participant, or at discipline and fitness to practice, it's about inappropriate conduct. So if you're constantly interrupting one of the parties, or if where the college's lawyer is talking, you're taking notes furiously, and as soon as defense counsel's talking, you lean back with your arms crossed and you're shaking your head, that's going to demonstrate that you agree with the college and you disagree with the members' council. So you should not be doing that. So thank you. Any other questions before I move to a few recent important cases? No? Okay. So the first one, and this is just sort of, I just went through some recent ones and thought, here's a sort of a sample of all over the place that cases that might be of interest to those of you particularly sitting on different committees, knowing that some of the committee work is often high risk. So this is the first case is from the Health Professions Discipline Tribunal, so from the CPSO. And so the case arose after a physician was convicted of a series of serious criminal offenses. He pleaded guilty in criminal court to harassing 13 young female victims from his car over a 6-month period. So almost everything was agreed upon between the parties at the discipline hearing, except one issue. So the registrant admitted the facts and agreed that they amounted to professional misconduct. The parties, so the college and the physician, also agreed that the penalty should be revocation and a reprimand. But what they didn't agree about was the registrant's lack of a prior history and how that, what that meant in terms of whether it was a mitigating factor on penalty or a neutral factor. And even though it wasn't going to impact the decision because it was a joint submission, and the tribunal felt that the standard for rejecting a joint submission had not been met, the tribunal was prepared to weigh in on the issue because the parties had, because it was an issue that was arising a number of times in the past, and because the parties had thoroughly argued it. And so the answer to the question, again, wouldn't change this tribunal decision, but the the tribunal felt that it was symbolically important in articulating sort of the basic expectations of physicians and the seriousness of the discipline history, because it had never been analyzed. And so their ultimate decision in terms of whether the fact that a member did not have a prior discipline history and whether it was a mitigating factor or a neutral factor, essentially the tribunal said how a lack of prior history should be considered is that it was because the case law had not been sort of consistent on these. The tribunal weighed in on it. So they essentially said that a prior discipline finding, so this doctor did not have one, but a prior discipline finding is generally called an aggravating factor, because when a registrant engages in misconduct after going through the discipline process once, a stronger sanction is required the next time. But the tribunal in this case said the same is not true of a previous ICRC level outcome, so a remedial outcome. And so instead, the court said that the tribunal said that you have to look at whether the ICRC took action. Where it took no action, that decision is irrelevant to the appropriate sanction and discipline. But an ICRC level decision could be used to demonstrate that the registrant was aware of an issue, sort of put on notice of an issue. But essentially, the tribunal determined that the absence of a prior discipline history is a neutral factor on discipline. So, which is different from the criminal law, where you essentially get credit, so to speak, for being a first-time offender. Instead, the tribunal said regulated professionals, when they become members of the profession, agree to govern themselves according to professional obligations and high standards. And members of the public are entitled to expect that professionals will adhere to those high standards. And it's inconsistent with those principles to give professionals sort of a break simply because they have not previously been found to have committed professional misconduct. Doing so would send the wrong signal to the public and the profession. So the takeaway really is that a professional where a professional does not have a discipline history, it's a neutral factor. They don't get credit for staying out of trouble. That's really a baseline expectation for members of the profession. So the next case is Welkoff, and it was an appeal to divisional court from a Health Professions Appeal and Review Board decision. And it includes some interesting guidance about the public nature of ICRC level outcomes, in which this college has more of the discipline outcomes. You've got more cases that are resolved at the ICRC level. And so the facts in this case rose out of a complaint by a patient about a physician. The patient had attended the emergency room experiencing suicidal ideation and expressing that she wanted medical assistance in dying. She was admitted to the psychiatric unit under the respondent's care. A patient was discharged but resisted leaving the hospital and expressed concern that the doctor really did not listen to or address the concerns. Ultimately, ICRC disposed of the complaint by allowing the physician to enter into a remedial agreement, which would not go on the public register. And so that likely those of you on ICRC know that the code, section 23 of the code, specifies that specified continuing education and remediation programs, SCRPs, or undertakings do get included on the public register. The code doesn't mention remedial agreements. So the issue really is a remedial agreement an undertaking? The College of Physicians determined that it was not, so it was not put on the public register. And the court accepted that a certain amount of deference was owed to the ICRC's decision about how to dispose of a complaint, but the court did raise concerns about that the remedial agreement appeared to have been crafted for the purpose of avoiding public disclosure, because a SCRP would go on the public register. So the court noted that it was not apparent from the findings and the fact that the doctor had a prior caution why this particular case would not fall into the more serious or greater risk category requiring a disposition that had to be disclosed publicly. So that rationale was not articulated in the decision. And the court found that if a particular disposition is chosen by a screening committee to avoid public scrutiny, that could factor into the court's assessment of whether the outcome was reasonable. So there's nothing wrong per se with remedial agreements if the facts are not serious, but ICRC dispositions, the court says, should not be crafted to undermine the transparency provisions in the code or to avoid public scrutiny. And I'm aware that many colleges do not use remedial agreements for this exact reason. So it's either they get advice because it's low risk activity and it's not going to go on the register, or there's a SCRP or an undertaking and it's going to go on the register. So it will be interesting to see whether, in light of this case, whether the college like CPSO continues to use remedial agreements. So the third case, this is about third-party contractors who carry out services on behalf of regulators, which all colleges use. And so this is BizTech and Accreditation Canada. So the College of Medical Radiation and Imaging Technologists, CMRITO, it approves educational programs that are accredited by Accreditation Canada, just like CDHO approves certain programs that are accredited. And BizTech is a private for-profit career college that offers certain kinds of paramedical education, including a diagnostic medical sonography program. CMRITO is another RHPA college, just like yours. And the council of that college determined through policy that a program had to be accredited by Accreditation Canada in order to be approved by CMRITO as an acceptable program for registration. Accreditation Canada had flagged problems with BizTech's program for a number of years, giving it a conditional accreditation status, but ultimately gave it not accredited status. So BizTech tried to go to court. It sought judicial review of the decision not to accredit it, arguing that it was unreasonable and procedurally unfair. And so a preliminary issue arose in that the respondents, which were Accreditation Canada, the CMRITO, and the Superintendent of Career Colleges, which is the Government of Ontario, argued that Accreditation Canada, their decision is not even subject, like not even open to judicial review, because the dispute was essentially a private contractual one between Accreditation Canada and BizTech. And so normally judicial review, sort of asking a college or court to review a decision, is available with respect to organizations or entities like the college that exercise a statutory power of decision, a decision made pursuant to a statute. And so that was the argument, is that you don't even have authority to ask for judicial review. The court, however, found that the CMRITO, the college, through its registration regulation, is authorized to approve programs or to delegate the approval power to another body. And by delegating that power to Accreditation Canada, that Accreditation Canada was then exercising a statutory power, which made its decision open to judicial review. So the court also held that the decision to terminate accreditation was of sufficiently public character that public law remedies were available. So essentially, the takeaway is that we know that the exercise of power by a regulator is often subject to the review by a court, but the same can now be said that regulators who are delegating important public interest decisions to third parties, like accrediting entities or entities that do prior learning assessments, that those might be open to judicial review as well. So this is the last case I'm going to talk about, and some of you may have heard about this, involving exam cheating at the Law Society of Ontario. So the Law Society obtained evidence that was quite compelling that one of their licensing exams had been compromised, and identified the candidates who were suspected of cheating, and it notified them of concerns and the actions that it was contemplating, and it gave them multiple opportunities to make written submissions, not oral submissions, not a hearing, but written submissions. And so the Law Society proposed to void their exam results, deem them to have not met the requirements for licensure, and prohibiting them from reapplying for at least 1 year. And to say as well that the cheating issue could be raised at the registration or licensure stage as a good character issue. And so the applicants, those candidates who were thought to have cheated, sought judicial review. They went to court to say, hey, we don't like this decision. And the divisional court, the decision from that level of court said that avoiding the exam results was okay. That could be done through a basis of written submissions. But the divisional court said nullifying the candidates' applications for licensure, the registration applications, could only be done at a hearing. So the Law Society appealed that, and the issue then really for the Court of Appeal was, what's the appropriate response? Was a written process sufficient, or was a hearing required? And the Court of Appeal actually allowed the appeal. It agreed with the Law Society that the Law Society could both void the exam results and nullify those candidates' application through a written process alone. And the court found that the Law Society's sort of legislation suggested that hearings were not required for those kinds of decisions, and that those decisions were not analogous to a disciplinary finding or even a good character determination, which would need an oral hearing. It also found that the Law Society had not created an expectation that a hearing would be offered, given that it processes hundreds of applications a year. So This is a departure from the previous approach that was with the CRPO registered psychotherapists, a case called Haramic a number of years ago, which suggested that a hearing was required, although in that case, Haramic had already been registered. So this is a really helpful case for regulators, and more regulators might now be trying to put similar provisions in their regulations or to allow them to have the authority to deal sort of expeditiously with applicants who are suspected of cheating, rather than having to deal with it through a formal registration, oral hearing or discipline. And so ultimately, the decision will depend on the wording of the particular legislation at issue. But this case was quite helpful, particularly because we've been living with the Haramic decision for a number of years. So those are just the 4 cases that I wanted to highlight for you today. And then just to wrap up, I'm almost done. I got one more slide. This is a bit of a cheat sheet for you. If you only take one thing away from today, make it this slide. Remember who you represent. That's the public interest. You've got undivided loyalty and diligence to the college's mandate. Each of you individually have no role independent of council. You should prepare and deliberate for the meetings. Once a decision's made, you need to speak with one voice. Avoid conflicts of interest where you have one. Disclose it, declare it, recuse yourself from the decision. Treat everyone respectfully, maintain confidentiality. Be familiar with the code of conduct and comply with it. And remember that self-regulation, even modified self-regulation where there are public members on council, it's a privilege that the government gives to you, and it's being lost. It's being taken away in many, many countries and across Canada. Regulating a profession is very complicated. You've got inconsistent and competing obligations. You've got obligations to be transparent, and yet you've got confidentiality obligations. So learn from others around you where you could see something in the front of the Toronto Star and you want to learn from it rather than just have a sense of schadenfreude. I love that word. Put the public interest above all else. And if you remember sort of the things on the cheat sheet, you will be going a long way to doing good work in a very important role in a public interest body. So any final questions at all or comments or thoughts before I hand it back over to Michelle? Vanessa.
Just wanted to say thank you, Julie. Your presentations are always very thorough, and the examples really help just narrow in on the issues and what we should keep in mind. So thank you.
You're very welcome.
Yes, I'll say the same thing that Vanessa said. Thanks so much, Julie. It's a really good reminder for those of us that have been on council for a while, and obviously good information for all of our new council members. It's really important for us to really understand the role of council and what our role on council is and all of our important responsibilities. So thanks very much. And those examples are very interesting and really bring home those points that you are making. So thanks again.
You're very welcome.
All right, council members, that is it for our January meeting. I just have a couple reminders, and I have way too many screens open with respect to just council evaluations. So again, we're going to be looking at this with our strategic plan with Kevin and our evaluation of council. So for now, we will continue with the survey, but there wasn't a lot that we discussed or decided on today at all. So this is a unique meeting, but I just want to remind everyone that our next meeting date is in March. So the council meeting is March 27th, 2026. We'll have our workshop on the Thursday. So March 26th will be our workshop day, and that is an in-person meeting in Toronto. So hopefully everyone can make it to Toronto for that meeting. And I'm just going to ask our new executive, if you could just stay on the meeting for a little bit. We're going to be determining committee slates so we can get those off to our staff support people so meetings can start to get scheduled for 2026. So we will call for adjournment. So if I could have someone move the adjournment of the meeting. Lori, seconder, Jenny, all in favor? Okay, that's it. So thanks everyone. Have a great day. It's a short and sweet meeting today. So you have